Civil procedure under the Philippine law, salient points. Jurisdiction. There are three jurisdictions under the civil law of the Philippines. These are jurisdiction over the subject matter, jurisdiction over the person, and jurisdiction over the res. Under jurisdiction over the subject matter, this is determined by law and cannot be conferred by consent or waiver. It refers to the authority of a court to hear and decide a particular type of case. Under the jurisdiction over the person, this is acquired through the proper service of summons or voluntary appearance. Jurisdiction over the res involves the power of the court over the property or status involved in the litigation. So again, three types of jurisdiction: subject matter, person, and res. Let's also talk about parties. There are three kinds of parties. We have the plaintiff, the defendant, and intervention. Plaintiff is the party who initiates the lawsuit. The defendant is the party against whom the lawsuit is filed, while intervention is a third party who may intervene in a case if they have a legal interest in the subject matter. Pleadings. We have three kinds of pleadings. We have the complaint, answer, and reply, CAR. Complaint is the initial pleading filed by the plaintiff stating the cause of action. This is the person complaining. This is pleading. While answer is the defendant's response to the complaint, which may include counterclaims or defenses, while a reply is now the plaintiff's response to the defendant's answer. Now let's talk about motions. We have motion to dismiss. A motion to dismiss is filed by the defendant to dismiss the case for reasons such as lack of jurisdiction, improper venue, or failure to state a cause of action. Now later in this video, we will talk about motion to dismiss as a prohibited motion. We also have motion for summary judgment. In this motion, there is a request for the court to rule in favor of the moving party without a full trial, and thus the decision or the ruling is based on the argument that there are no material facts in dispute. How about service of summons? We have three ways of doing service of summons. We have personal service, substituted service, and by publication, PSP. So let's start with personal service. This is delivering the summons directly to the defendant. While substituted service, this is if the personal service is not possible, then leaving the summons with a competent person at the defendant's residence or place of business is allowed. Otherwise, we can do publication. This is used when the defendant's whereabouts are unknown. What's the difference between a pre-trial and a trial? In a pre-trial, the purpose is to simplify the issues, consider the necessity or desirability of amendments to the pleadings, and discuss possible settlements. In result, there is a pre-trial brief which is submitted by the parties outlining now the facts, issues, and evidence to be presented. While in a trial, this is now the presentation of evidence. In this scenario, both parties present their evidence, including the testimonies and documents. Now, in a trial, the burden of proof lies on the plaintiff to prove the allegations by a preponderance of evidence. Later, we'll discuss preponderance of evidence. How about judgment? A final judgment conclusively determines the rights of the parties. But we also have interlocutory orders. Take note, these are only interim rulings that do not resolve the case entirely. How about appeals? For period for appeal, generally an appeal must be filed within 15 days from the receipt of the judgment or final order. If there is a need to appeal, it should be addressed to the Court of Appeals and the Supreme Court, depending on which jurisdiction it falls. In terms of execution of judgment, we have this writ of execution, which is issued to enforce a final and executory judgment. However, there are instances that the order is on stay of execution, which may be granted under a certain circumstances, such as the party filed a supersedeas bond, and we will discuss that also in this video. How about alternative dispute resolution, or ADR? There are two kinds. We can have arbitration or mediation. In an arbitration, this is a binding process, meaning the decision is binding to both parties, whereby a neutral third party renders a decision. While in a mediation, this is a non-binding process because a mediator simply facilitates and helps the parties reach a settlement. We also have under civil procedure special civil actions, and there are three of them, CPM. These are special civil actions. We have certiorari, prohibition, and mandamus. So what's the difference between the three? When we say certiorari, there is a review of a lower court's decision on the ground of lack of jurisdiction or grave abuse of discretion. Those are the only two grounds of certiorari, the lack of jurisdiction or the grave abuse of discretion under certiorari special civil actions. In terms of prohibition, when you file for prohibition, this prevents a lower court from continuing with a proceeding beyond its jurisdiction. And finally, a special civil action of mandamus compels a public officer to perform a duty that is required by law. Now, as I said earlier, a motion to dismiss is a prohibited motion as a general rule, although there are certain circumstances that this can be exempted. Now, under the amended 1997 Rules of Civil Procedure, or the revised rules, which became effective last May 1, 2020, the rules regarding motions to dismiss have been revised, and the purpose of which is to expedite the resolution of cases and also prevent unnecessary delays, because these motions are sometimes filed just to delay the proceeding. So as per Rule 15, Section 12 of the revised rules, a motion to dismiss is generally considered a prohibited pleading. However, there are specific exceptions where a motion to dismiss can be filed. And what are these? So these are the exceptions whereby a motion to dismiss is allowed to be filed. There are three. One is lack of jurisdiction over the subject matter. Two, litis pendentia. And three, res judicata, or also prescription. So one, under lack of jurisdiction over the subject matter. If the court does not have jurisdiction over the subject matter, the motion to dismiss can be filed because jurisdiction is determined by law and cannot be conferred or waived by the parties. The second exception is litis pendentia. If there is another action pending between the same parties for the same cause of action, a motion to dismiss can be filed to avoid multiplicity of suits. And finally, in cases of res judicata or when prescription is applicable. Meaning, if the cause of action is barred by a prior judgment or res judicata or by the statute of limitations, a motion to dismiss can be filed to prevent relitigation or time-barred claims. Now, what is the procedure for filing a motion to dismiss? When there is an opposition to that to that motion, the adverse party may file an opposition to the motion to dismiss within 5 calendar days from the receipt of the motion, and that party need not wait for an order from the court. And in terms of resolution, the court must resolve the motion to dismiss within 15 calendar days from its receipt of the opposition or upon expiration of the period to file such opposition. So remember, the adverse party has only 5 days to oppose the motion, while the court has 15 days to resolve or to dismiss the motion. Now, it is within the court's discretion to call for a hearing on the motion within that 15 days. But definitely in 15 days, the court will either resolve the motion to dismiss, the court will call for a hearing or resolve the motion to dismiss. And the opposition, again, has only 5 days from the receipt of motion to file its opposition. Now, what if the motion to dismiss is granted? Now, if the motion to dismiss is granted, definitely, of course, the case is dismissed. However, there are 2 dismissals that can happen. It can be a dismissal without prejudice or a dismissal with prejudice. Now, when we say it's a dismissal without prejudice, the plaintiff is allowed to refile the case after correcting whatever defect was found. But if it is a dismissal with prejudice, the plaintiff is now barred from refiling the same cause of action. Now, if it's a dismissal with prejudice, meaning the plaintiff cannot anymore file the same cause of action. In other words, this is an order granting any of the following results in a dismissal with prejudice, thereby now barring the refiling of the same action or claim. So it could be based on this dismissal can be based on a motion to dismiss, as we have discussed earlier, or it can also be a result of an affirmative defense. So that means that the cause of action is barred by a prior judgment or by a statute of limitations, meaning in the response of the or the reason that the motion to dismiss or the affirmative defense was granted, the affirmative defense raised is because there is a prior judgment, or this is your res judicata. Or another affirmative defense is that the claim or demand set forth in the plaintiff's pleading has been paid already, waived, abandoned, or extinguished, or that the claim on which the action is founded is unenforceable under the provisions of the statutes of frauds. So these are examples of dismissals of cases that the court would say dismissal with prejudice because one cannot refile anymore the same action or claim. So what are, as mentioned earlier, affirmative defenses can be filed in lieu of motion to dismiss. Okay, so what are these affirmative defenses? So these are failure to state a cause of action. So if the complaint does not allege facts that constitute a cause of action, a motion to dismiss can be filed. Now, this means the complaint fails to show that the plaintiff is entitled to the relief sought. However, take note, with the new ruling, there's a motion to dismiss is already a prohibited motion. So instead of filing it as a motion to dismiss, we can now put it as part of affirmative defense in the answer. Another one is the forum shopping. If the plaintiff is engaging in forum shopping before a motion to dismiss can be filed, but now you include it now in the affirmative defense. Now, forum shopping occurs when a party attempts to have multiple courts hear the same issue, hoping to get a favorable decision. Then we have the lack of legal capacity to sue. Now, if the plaintiff does not have the legal capacity to file the lawsuit, in the past, we file a motion to dismiss. This time, it is now one of those affirmative defenses that we can include in our reply. This could include instances where the plaintiff is a minor or lacks legal standing. So, as I said, when the grounds for a motion to dismiss are instead raised in the answer as affirmative defenses, the court will conduct summary hearing within 15 calendar days from the filing of the answer. And the court will motu proprio resolve these defenses within 30 calendar days. So if you see, the difference is in that motion to dismiss, one can file within 15 days a motion to oppose, but the court will do a summary resolution within that 15 days. In a motion, in a affirmative defense, the court will conduct a summary hearing within the 15 calendar days and motu proprio resolve these defenses within 30 calendar days. So just to compare, here, if a motion to dismiss, the opposition files a motion to dismiss within 5 days, and the court will resolve the motion in 15 days. And the court has a discretion to call for a hearing within that 15 days. But in an affirmative defense, okay, the court will conduct a summary hearing within the 15 days, and the court will motu proprio resolve these defenses within 30 calendar days. So that would be now the difference between that motion to dismiss, which can only be used for those 3 instances, which are lack of jurisdiction over the subject matter, litis pendentia, and res judicata or prescription. And the rest will have to be raised in the affirmative defenses, which are failure to state a cause of action, forum shopping, and lack of legal capacity to sue. Because again, there is now a general rule that motion to dismiss is a prohibited pleading. Okay. Now, what if the affirmative defense is denied? Now, take note, when the affirmative defense in a reply is denied, this is not appealable. So the denial of an affirmative defense cannot be a subject of a motion for reconsideration or those special pleading, special action, which is certiorari, prohibition, or mandamus. So no filing for motion for reconsideration or no petition for certiorari, prohibition, or mandamus. Instead, that denial may only be raised on an appeal after the judgment on the merits of the case. Okay, so we wait for the judgment on the merits of the case. Now, there is a discussion that in civil law, the basis for judgment is on the preponderance of evidence. So what is preponderance of evidence? Now, this is the standard of proof commonly used in civil cases. It refers to the level of evidence required for the plaintiff to win the case. So in the context of civil litigation, preponderance of evidence means that the party with the burden of proof, who is the plaintiff, must show that their claims are more likely to be true than not true. Okay? So in other words, when we try to balance the evidences as presented by the plaintiff and the evidences presented by the defendant, although we know that the burden of proof lies on the plaintiff because he is the one who alleges. So the evidence presented by one side must be more convincing and probable in truth compared to the evidence presented by the opposing side. And that's how we evaluate who has the better evidence or the preponderance of evidence. Okay, so it is often described as more likely than not, or it's greater than 50%. In other words, in the balancing scale, whoever has better evidence will win the case. That's the basis of preponderance of evidence. In other words, when we compare that preponderance evidence to the other forms of basis for judgment, which is beyond reasonable doubt and clear and convincing evidence, this is a much lower form of basis, because in a beyond a reasonable doubt basis, this is used in a criminal case. This standard requires a very high level of certainty, around 95 to 99%. Remember, it's beyond a reasonable doubt. While the next level, which is clear and convincing evidence, this is a higher standard than preponderance of evidence because it requires a higher probability of truth, although not as stringent as beyond a reasonable doubt. So in terms of application in civil case, okay, a contract dispute, a personal injury claim, property disputes, plaintiff must meet the standard in order to win. So contracts, personal injury, claims over property, who has the better right. So it is preponderance of evidence that we use here. So the defendant may also have to meet the standard if the defendant would raise a counterclaim or a defense. Okay? And in terms of decision-making, the judge or jury, but we don't have a jury, so we have the judge, weighs the evidence from both parties, and the decision hinges on which side's evidence is more convincing or more credible or has more weight. Okay, so it's really just weighing between the two parties' evidence, who has the better weight. So this is an example of preponderance of evidence. So imagine a personal injury lawsuit where the plaintiff claims that the defendant's negligence caused an accident. So to meet the preponderance of evidence standard, the plaintiff must present, again, it's the plaintiff who should present evidence showing that it is more likely than not that the defendant's negligence has caused the injury. So what are the evidences that the plaintiff can present? He can present an eyewitness testimony or a photograph of the accident scene, medical records linking the injury to the accident, or an expert testimony supporting the plaintiff's claim. So if the evidence would show that it is quite convincing, then the plaintiff would be able to prove preponderance of evidence on his side. So if the judge finds that the plaintiff's evidence is more credible and convincing than the defendant's evidence, then the plaintiff will meet the preponderance of evidence standard and win the case. So why is this kind of judgment applied in civil law? So the preponderance of evidence is crucial in civil law because it ensures that cases are decided based on who is most likely telling the truth or who is most likely truthful in relation to allegation, rather than trying to prove for certainty, which is sometimes not possible. The goal here is simply to balance the need for each party for fairness, giving plaintiff an opportunity to prove their claims while also protecting defendants from unfounded accusations. Now, earlier there was also a statement, a kind of judgment that says stay of execution. So what is a stay of execution? This is a court order to temporarily suspend the enforcement of a court judgment or order. This means that the winning party in a case cannot immediately enforce the judgment against the losing party. A stay of execution can be granted under certain circumstances. This is to ensure fairness and prevent undue hardship by right away executing the order. So what are the key points in terms of implementation of the stay of execution of judgment? So again, as we said, the purpose of which is to provide the losing party the opportunity to appeal the decision without immediately suffering the consequences of the judgment. To ensure that the appeal process is meaningful and is not rendered moot by immediate enforcement of the judgment. So we allow the appeal to prosper. Now, what are circumstances needed for the stay of execution to be granted? Well, the party has to file an appeal. Okay, so often granted when the losing party files an appeal, this is to indicate that the decision is not yet final and executory. There is a pending motion. Granted, if there are pending motions, such as a motion for reconsideration or for a motion for new trial, then whatever the judgment that was passed on has to be stayed. Okay? And other special situation in cases where immediate execution of judgment may have an effect that is irreparable, can be harmful, can be damaging, and the interest of justice requires that we hold off on that execution of judgment. Okay? In terms of procedure, it is the losing, of course, it's the losing party who files a motion for a stay of execution with the trial court or with the appellate court, wherever the appropriate jurisdiction is. The court then evaluates whether the appeal or the writ for stay being appealed for is warranted based on the specifics of the case and the applicable laws or rules. Now, in terms of duration, a stay of execution is temporary and it's only, it lasts until the appeal or the pending motions are resolved. And the court specifies the duration or the conditions associated with the stay of execution. Now, in the process of filing that writ of stay of execution, there is a bond required. This is the supersedeas bond. A supersedeas bond is also known as an appeal bond. It is a type of surety bond that the appellant, the one who's appealing for the execution of the stay of execution, this appellant is required to post or obtain. They have to post a bond to obtain the stay of execution pending appeal. Now, what is the bond for? This is meant to secure the appellee, the one who won the case, the right to recover judgment upon or the money that that is due to him, and any other potential additional cost if the appeal, the appeal to a stay of execution or there was an appeal to reconsider the case or review the case, if that was not successful and the judgment remains, then the appellee will have the right to recover right away whatever judgment is awarded to her, including other potential costs that would happen because of the stay of execution of judgment. So the key points here are the supersedeas bond is actually to protect the appellee from the risk of not receiving his payment during the appeal process. Okay? And then this is also to ensure that the appellant, the one who's filing, the losing party who's filing the writ of stay of execution, is really genuine and serious that he wants his case to be appealed on because he really believes there is some weight on what he is appealing on. And this is to discourage frivolous appeals. And how much is the bond? So this is usually set by the court and often includes the full amount of the judgment plus interest and any additional cost or damages that might accrue during the appeal. So the exact amount will really vary depending on the jurisdiction and the specifics of the case. Okay? Now, in terms of filing process, the appellant must secure the bond from a surety company and file it with the court, and it needs a court approval to be effective. Once the supersedeas bond is filed and approved, the stay of execution of judgment is granted, thereby suspending now the enforcement of the judgment. And after the appeal, if the appeal is not successful, the bond will ensure that the appellee can collect the judgment money due to him without any further delay. And if the appeal is actually successful, meaning they have to reverse the judgment, the bond is released and returned to the appellant. But if the appeal is unsuccessful, the bond is used to satisfy the judgment, including any additional cost awarded by the appellate court. Okay, so example to that would be this. Now consider a scenario where a trial court has awarded a monetary judgment against a defendant. So the defendant believes that the judgment was incorrect and decides to appeal. To avoid immediate enforcement of the judgment, the defendant files a motion for a stay of execution and posts a supersedeas bond. The court grants the stay, suspending the enforcement of the judgment until the appeal is resolved. Now, if the appellate court upholds the trial court's decision, the bond ensures that the plaintiff can collect the judgment amount. If the appellate court reverses the decision, the bond is released back to the defendant. Okay, so that's it. Some salient points on the civil procedure of the Philippines. If you find the video interesting, please don't forget to like, share, and subscribe. Thank you very much for listening.